In this video, I discuss things to consider when owning and selling real estate and some practical tips about transferring property from one to another. One thing to consider is how the real estate is owned. Usually, real estate is owned by an individual, but that person can also control property through a business entity, like a corporation or an LLC, or through a trust. If two or more people own property, they can own it as tenants in common or as joint tenants. They can also own the property as a business or as a trust as well. As joint tenants, if one of them passes away, then the survivor will own the other's share without having to go through probate. Spouses usually hold property as community property, but they can also own that property with right of survivorship, just like joint tenants. Other things to consider are the tax benefits and consequences. With income tax, on selling real estate, the seller may have to pay taxes, usually as capital gain, which is taxed at a lower rate than ordinary income is. The tax is also based on the value of the adjusted basis of the property, which is usually the original cost of the property plus any costs of improving it. Now, if you are a homeowner and you sell your principal residence, you can exclude up to $250,000 of gain from the sale, or $500,000 if you and your spouse are jointly filing taxes. You must have owned the residence for 2 of the past 5 years before you sell the property. Now, while owning the property, you can deduct mortgage interest payments and property taxes. You could also take business deductions on a second home, but this depends on the amount of personal use that you use for the home. Property taxes are calculated with the property's basis, as I had mentioned earlier. But basis can be reassessed with a change of ownership and increase the amount of tax. For example, when property is sold, ownership changes hands and the basis increases to the selling price. However, reassessment is subject to exclusions. Common types of exclusions occur with family, for example, between spouses, between parents and children, and from a grandparent to a grandchild. And the exclusion also includes transfers into trust between spouses. For transfers into trust, you should identify the property in the trust instrument. The grant deed must also state that the recipients are holding the property as trustees. And when filing the deed, the assessor recorder requires other forms too, so seek help from an attorney. There are many other things to consider, and this is merely an overview. Please contact me with any questions. Thank you.